Good afternoon, everyone. I'm calling this meeting of the Douglas AMA Groundwater User Advisory Council to order. Today is Thursday, May 23rd, 2024. The time is 1:01. I am Nick Mason, the GUAC coordinator. Would the council members please introduce themselves?
I'm Ron Bemis, rancher from McNeil area.
Tony Giacomino. I'm from Bisbee, but I have property in the valley. Jackie Watkins, farmer in McNeil.
Elise Moore, I'm the Public Works Director, City Engineer for City of Douglas.
Could you speak up so we could hear you?
Pull your mics down. So you do this when I get to it. Elise Moore, I'm the Public Works Director, City Engineer for City of Douglas. I'm also a resident of Douglas.
Thank you.
Thank you. We have a quorum. Would ADWR staff members please introduce themselves? My name is Nick Mason. I'm the GUAC coordinator.
Aaron is here now.
Ryan Melson, Deputy AMA Director.
Keith Dillon, AMA Establishment Supervisor.
Madison Marina, AMA Establishment Coordinator.
Thank you. I'll now move to agenda item 2, the meeting logistics. Good afternoon, everyone. I'd like to go over some of the meeting logistics for the public in attendance. We ask that you please keep your phone silence during the meeting. We ask that all present online please keep their audio muted during the meeting as well. This meeting is being recorded and will be posted to ADWR's website and YouTube page once the recording is generated. Presenters, please ask the next slide when presenting your agenda item. And finally, if you're having any technical difficulties, please contact our help desk. Their contact information can be found on the screen. Thank you.
Nicholas,
Yes,
would you mind having Aaron introduce himself?
please. Mr. Cardona, if you could introduce yourself.
My name is Aaron Cardona. I run Arevalo's Farm, third generation Mexican American vegetable organic farm.
Thank you. We will now move into agenda item 3, the overview of council member responsibilities, presented by Ryan.
Good afternoon, and thank you to all council members and members of the public for being here today in person and virtually. I'll provide an overview of the responsibilities of our Groundwater Users Advisory Council by talking through the Arizona Revised Statutes 45-420 and 44-421. Then we'll explain the format and content for our GUAC meetings going forward. Next slide, please, Nick. The first regulation here is ARS 45-420. This regulation centers around council composition in terms of agreement for the council members. So the GUAC in each active management area consists of 5 council members who are appointed by the governor. The council members represent groundwater users and are chosen for their knowledge, interest, and experience with water issues. Each council member serves a 6-year term with staggered term expiration dates. Members serve without compensation, but are reimbursed for travel and subsistence for matters that are related to council business. Next slide, please, Nick. The second regulation is ARS 45-421, which is the council duties. The GUAC has several key responsibilities in the AMAs. So one is advising the AMA director on groundwater management programs and policies. The second is keeping and maintaining permanent records of its meetings and actions. The third is electing a chairman and vice chairman every 2 years. Fourth is designating individuals to execute documents on behalf of the council. 5 is documenting actions through motions or resolutions. 6 is maintaining records open for public inspection. And 7 is providing input to the Arizona Water Banking Authority on storage and operation plans. Next slide, please, Nick. This is the same slide as the previous slide, but it highlights in blue what ADWR will assist the council with. So points 2, 4, and 6 are things ADWR will be doing, and then points 1, 3, and 5 will be handled by the council. So the council members will be responsible for advising the area director on groundwater management programs and policies, including management plans. Responsible for electing a chairman and vice chairman every 2 years, and documenting actions through motions or resolutions. ADWR will take care of keeping and maintaining permanent records of its meetings and actions, designating individuals to execute documents on behalf of the council, and maintaining records open for public inspections. Point 7 focuses on providing comments, and you see it slashed out there with a strike through. It provides comments to the Arizona Water Banking Authority, but this is not applicable to Douglas AMA because the statute only mentions Phoenix, Pinal, and Tucson AMAs must provide comment to the Water Banking Authority. So point 7 is crossed out on this slide because it's not applicable to the council members here in Douglas. Next slide, please. Thank you. For format of future GOAC meetings, we wanted just to talk a little bit about that. So the format of future GOAC meetings will be formal public sessions subject to open meeting law, which my colleague and our attorney, Anthony, will go over in more detail shortly. There needs to be a quorum, so 3 out of 5 members need to be present to hold a meeting. A meeting can still occur without a quorum, but it will only be considered an informational-based discussion, and no formal decisions can occur when there is less than a quorum present. The council chair will lead the meeting with support from ADWR here. Discussion items must be listed on the agenda, and items not on the agenda can be tabled for the next GOAC meeting. And the last point is items requiring recommendations or decisions will be explicitly listed on the agenda and formalized through a motion and vote procedure. Content of future GOAC meetings. So in terms of content for GOAC meetings, there will be updates related to water conditions, water usage, water data, water management, and water related regulations as well. There will also be discussions and recommendations on groundwater management programs and policies, including the management plans, which Madison will go into today. The last 2 points that are crossed out are generally applicable for other AMAs, but they are not applicable to the Douglas AMA because there's no withdrawal fees in Douglas because the Arizona revised statutes do not specifically mention Douglas for withdrawal fees or subsequent AMAs more generally for withdrawal fees. So if there's no withdrawal fees, there's no money available for the groundwater conservation grants since the withdrawal fees in the other AMAs provide funding into the augmentation and conservation assistance fund for augmentation or conservation assistance projects that will benefit that particular AMA when the monies are collected in those AMAs. Again, since there's no withdrawal fees in Douglas, there will be no need for discussions or recommendations on withdrawal fees for conservation grants. Next slide, please. Thank you. And if you have any questions or need further clarification, please feel free to reach out to Nick Mason, our GOAC coordinator running the meeting today. Go ahead, Ron.
I just had one question. Yeah. When you said we have to post our meetings, who is responsible for posting them and where do they get posted?
I will be posting meetings as soon as the recording is generated to ADWR's YouTube page as well as the website.
So that's a DWR responsibility, not a council's. Thank you.
That's correct. Yeah.
And there will be a little bit more additional detail in my presentation.
Okay, thank you.
Excellent. And also please feel free to use the other general AMA customer service inbox as well for any questions for any members of the public today. So I will turn the floor back to Nick.
Thank you. We will now move to agenda item 4, the election of officers. The council members will elect a chair and a vice chair to serve a 2-year term. We're hoping this will be an open discussion. We can come to and the council can do a resolution.
Does anyone volunteer for it?
What are the responsibilities as such? Is it just generally guiding the meetings or are there any additional responsibilities?
The chair and the vice chair in the chair's absence will serve to guide through the meetings, begin the meeting in session after a quorum is established and adjourn the meeting at the end. They will also be responsible for communicating with me over what they would like to see on the agenda specifically. Yes.
I'd nominate Jackie Watkins as the chairman.
A second.
Ms. Watkins, are you willing?
Okay,
I heard you say accepted.
I accept.
there's no other nominations for chair, and we have 3 members of council agreeing to that motion, I would suggest that we move forward with that resolution.
I'll vote.
All in favor?
All in favor?
Aye.
That's, and then for vice chair.
Everyone's looking at me.
Aaron.
I accept.
All in favor?
Aye.
Aye.
Motion passes. We have
Nice.
chair and vice chair. And as we explained earlier, the script placed in front of you will guide you through the remainder of the agenda. It's the chair's responsibility to agenda item as we arrive to it.
So the next agenda item is number 5, open meeting law overview, and that will be presented by Anthony.
Yes. Good afternoon, council, members of the public.
Sorry to interrupt. A quick note, please explain to all presenters, please explain your slides thoroughly. There are some members of the public who are reporting issues online viewing the presentation.
Great, thank you, Nick. All right, so today I'm going to be giving an overview of some of the open meeting laws here in Arizona. I would like to stress that it is your responsibility to make sure that you are abiding by these laws, and we'll get into a little bit more about what that means, your responsibilities, and any repercussions that may come from any slip-ups. Next slide, please. So legislative intent of open meeting law is aimed at providing openness in government. Arizona's public policy requires that official deliberations and proceedings be conducted openly, and any uncertainty should be resolved in the favor of open and public meetings, meaning that the law is meant to construe something in favor of an open meeting over not, as long as it can come near definitions. Next slide. Some of the resources that help guide you through these laws and regulations are provided on these slides. Those would include Arizona Revised Statute sections 38-431 through 38-431.09. As well, there are some opinions of the Arizona Attorney General that can be found in the Arizona Attorney General opinions at the provided website, the azag.gov. And you also notice throughout the presentation, some of those citations will be provided to you at the bottom of the slide. Next one. Now we will go over who is subject to open meeting law. Next one. Okay. So open meeting law will be applicable to any public bodies here in Arizona. Now, public body means the legislature, all boards and commissions of the state and political subdivisions, as well as various government bodies, agencies, institutions, and instrumentalities of the state or of political subdivisions. All quasi-judicial bodies and all standing, special, and advisory committees or subcommittees of or appointed by the public body, and all commissions and other public entities established by the Arizona Constitution or by way of ballot initiative. Now, the way this works with the council here, the Department of Water Resources would be a political body of Arizona as an agency of the state, and the GUAC is an advisory committee to AWR. Therefore, open meeting law would apply to you in your way. Next week. I should have mentioned this earlier. If you have any questions at any time, please just interrupt and stop me. So a little bit more on advisory committees and subcommittees, as that is what specifically applies to the council here. That is defined as any entity, however designated, officially established on motion or order of the public body or by the presiding officer, and that is appointed to make recommendations concerning a decision to be made or considered by a public body. Next slide. And as mentioned, as an advisory committee, you must comply with all requirements of open meeting laws. And in addition to that, whenever there is a meeting of the council, minutes must be taken or recordings must be made. I believe this will come up a little. Yes,
Who's responsible for taking the minutes?
that would be.
The meeting is being recorded, and that's my responsibility.
Okay, thank you.
And this will come up again later, but I should just stress to make sure that when the minutes are being done by recording, that we get some confirmation that the recording is clear and can be clearly heard. Next slide, please. So when does the open meeting law apply? As I mentioned, any meeting of the council is when these all will apply. That is defined as a gathering in person or through technological means, which could be phone, email, fax, and in today's day, even a Zoom meeting or any other web-based interface like that count. That is made up of a quorum that discusses, proposes, or takes legal action. So that can include deliberations and can include one-way electronic communications that propose legal action and/or an exchange of electronic communications that involves discussion, deliberation, or legal action. So a lot of words. We'll get into a little bit more of the specifics of each of those in the next coming slides. So to begin, we can, next slide. We'll discuss what a quorum is. So generally in Arizona, a quorum is a majority of a board or commission. Look to your statutes and rules just to make sure that that is applicable. It is at this moment to the council, but of course, law is living, so anything can change. And keep in mind that vacancies do count. So right now we are a council of 5, so that means 3 would be a quorum. Should there be a vacancy during the meeting of the council and there's only 4 members, 2 members is a quorum. Next slide. Now we will get on to, did I skip this slide? Okay. But instances when you don't have a meeting is anytime that there's a gathering of the council where you are not discussing any business. Now, anytime that there is a quorum, we'll get into this, it would be advisable to alert the public to this gathering, whether or not you're discussing business, just for ease of showing that you're in compliance with the regulations. So that would mean that, say, a quorum, 3 of you, 4 of you are going to be gathering together for some sort of city event that has nothing to do with your role here as the council. You may still want to send out a notice of a quorum. We'll get into a little bit more of that. Also, beware of serial communications. In the previous slide, I mentioned one-way communications. So that means if you send an email to 2, 3, 4 of your colleagues here on the council, and you are proposing legal action, that can create a serial or an electronic quorum. And as well, if you send one email to one council member, and then you send the same email to a second and third council member discussing the same thing and sharing the views of your colleagues that were received in response, you can create a quorum and you can create a quorum through serial communications in that instance. So,
Okay. So we're on the Sulphur Springs Water Alliance.
mhm,
We're all on different committees and we're part of the group that initiated it.
mhm.
So we have meetings every month talking about how we can do for recharge, water augmentation and stuff for both the Douglas and Wilcox Basin. So we're not discussing stuff that would be the plan for the AMA,
Mhm.
but we're still discussing water stuff and recharge and groundwater and what we can do. So when we're together, if there's three of us, that's a quorum.
It is, and it would be advisable to notice that. However, if you don't, that is okay. You just need to be sure that you're not discussing business that could come before you as the council. Now, as I mentioned, it is recommended to put out a notice of quorum. And that could be just, when you know you're going to meet, you could put out a simple little notice. We can put that together very quickly, just meeting to make sure that we can get the requisite 24-hour notice. And if these are going to be regular standing meetings, when you might know that they're going to occur every, last Friday of the month, we can kind of have an ongoing notice of quorum. But the purpose of that notice of quorum is just to let the public know, hey, we realize that quorum is gathering. We can assure you that we're not going to be discussing business. We're trying to be upfront and open, as the law suggests, and that will satisfy.
Okay, and if there's only two people going and it's not a quorum,
Not applicable.
can you still discuss AMA issues?
As long as it's not going to be business that will come before you as your in your role as the council member. And that's like I said, that's kind of just as a show of pride that you're being mindful of the fact that you will be gathered. All right, next slide, please. If more than a quorum may be present as was discussed, this would be a courtesy notice. And I'm not saying that the quorum may be present. And as mentioned, we will include a notice to the public that no business will be discussed, because this is just happens to be that you all are gathering together for either, a meeting like that, or maybe there's a city event, or, what have you. Of course, you're not prevented from speaking to each other. You're not prevented from being friends with one another. It's just a way to show the public that we're being open and actively attempting to do our best to comply with this. The last bit about members should avoid talking to each other or have a witness. Of course, you can talk to each other when you gather together for your role. As mentioned, you will need to talk to each other. It will be helpful if there are others present that can, should somebody question whether or not you are following the rules of the open meeting law, that can thereafter testify on your behalf, perhaps, if it gets that far, or at least that can vouch for you that no business was being discussed. All right, we're going to move on to discussing, proposing, or taking legal action now. So normal use and meaning of these words will apply. That's typically the case with Arizona law, unless there's a definition provided. So here we have legal action means a collective decision, commitment, or promise as defined by ARS 38-431(3). Proposing legal action is defined as putting forward or considering, putting forward for consideration, discussion, or adoption. That includes deliberations, discussing of facts or opinions, which is potential board business. Now, if you're just discussing the merits of somebody's outfit, obviously not going to be business that will be coming forward before the council. But if it is business that may come before the council, that would be that deliberation would be proposing legal action. And this, if this occurs among a quorum, that is a meeting. Now, as I mentioned, a quorum gathering is fine if you're not discussing business. That's not a meeting. As soon as you start to propose legal action, that is a meeting that needs to be noticed. Looks like. So proposing an agenda item is for Via email is allowed if you do not promise legal action, so or propose legal action. So you can suggest a topic for discussion that will come before, but don't provide your viewpoints. Don't try to gather a vote. Do you know, what are you? Hey, I propose discussing item A. What's your opinion of that? As soon as you cross that line of just setting it forward, that becomes proposing a legal action. So you can just suggest a topic, but as soon as you start to discuss it any further, that's where the line is drawn. Communicate the topic only, not the legal action that you want the council to take, and then as mentioned, do not discuss, deliberate regarding the proposed agenda item. One-way emails from staff is the same thing. If you are suggesting a topic of discussion, and somebody on your staff sends it around, that's totally fine, as long as they're not engaging in the actions that were described on the previous slide. That would be a violation of the open meeting law as an agent of you in your role on the council. And this would include agenda packets and any agenda packets that are sent around to the council, whether by yourself or staff members. These need to be made available to the public, which we will take care of on our end. That's it. Telephone conferencing is allowed as long as approved for the body. Notice and agenda should indicate telephone participation. The public must be able to hear, just the same as we mentioned with any video conferencing that's happening. If you just do a telephone conference, you need to make sure that your audio is clear. Minutes should identify telephone participants and describe how the members of the public can access this meeting. And for more information, there's an informal AG opinion that was issued March 13th, 2020. Regarding open law and COVID-19. So how do you comply with the open meeting law? Best ways are to find a good location. Meetings must be accessible, discourage any procedures that obstruct or inhibit the public attendance, such as remote or inadequate location. Make sure the room is big enough and make sure it's not down some dirt road that you need four-wheel drive access. You cannot require signing sheets, though, as will be discussed later, any participants must give their name for the purpose of identifying them within the minutes. And don't set it at midnight. Make sure it's at a reasonable time and out, or 3 in the morning. Bad times for me. So location, can you move the location to another spot close to the original location? Say, you know, the internet goes out, there's a water main break. Yes, of course, you don't need to hold your meeting in a flooded room just because you noticed it. Just make sure you leave a staff person who will be able to give directions to the location, the new location. Post a large notice and try to start the meeting a little later just to give people time to find the new venue. Now, providing statement and notice, public bodies of the state, counties, and school districts shall conspicuously post a statement on their website stating where all public notices of their meetings will be posted. We should make sure to include physical location and electronic locations for these, and give additional public notice as is reasonable and practical. Now, as Nick mentioned, the notices will be posted on our website as well as at the EWR itself. If you are able to, and you know, it's reasonable to post an additional notice on the venue itself, that's great. But as is stated on our own website, ADWR's location in Phoenix is where those notices get physically published. Make sure that you, if there is a technical problem or failure that prevents posting or use of the website, does not preclude holding the meeting if the public body complies with ARS 38-431.1 2.02A, and all other notice requirements. Those can be found, but that includes the physical posting and making sure that you give proper notice. Currently 24 hours. That may change. There's actually currently legislation that would bump that up to 48 hours. So might as well get ahead of the curve and attempt to try to post those 48 hours ahead of time. Notice of meetings, as I mentioned, require 24 hours in advance. We're going to start the practice of 48 hours just in case that bill becomes law, which is quite likely. Those notices must be available to all members of the public body and to the public body posting at the locations described. Contents of the notice indicate which public body will be gathering. So in this case, the GUAC, the time, date, and place of the meeting. So if there's a room number, if it's going to be held at a large campus of some sort, make sure to include that and an address. Include the agenda or how the agenda can be obtained after the meeting. And if there is going to be an executive session, make sure to include that within the agenda and the notice of meeting. And make sure that you're citing the correct statutory authority to go into executive session, and ensure that accommodations under the ADA are either provided or give information for somebody to contact so that they can make sure that they can access the venue and the meeting. Resume and recess and resume meetings. So if there is an issue very last minute or during the meeting, internet goes out, power goes out, and you need to recess, you can, and resume within with less than 24 hours of notice. If proper public notice was given at the beginning, prior to the meeting, and prior to recess, notice is publicly given regarding the time and place of the resumed meeting, or regarding the method by which the notice shall be publicly given. So if you're sitting here and the power goes out and you decide to recess and reschedule, just let the public that either is attending in person or listening in via telephone or web conference, how they can access the new notice that will be provided for the rescheduled meeting. And that will be, of course, on our website at ADWR. Agendas. Agendas must include matters at the meeting to be discussed, considered, and or decided. And these, the agendas must contain information reasonably necessary to inform the public. So now that looks like the last bit about making sure it's understandable. No acronyms, statutory citations is not enough without explanations. No legalese and no agency slang. Let's try to just use typical plain English. And if we're saying that the Groundwater Users Advisory Council is going to meet, we're going to put that rather than just meeting the GUAC and such. Agenda items. You need to include specific items to be discussed, considered, or decided, and you need to provide enough detail for the public to be aware of that, of what that will actually be. So not just new business, not just old business, not personnel decisions or announcements. Maybe a little bit more specific on what we're going to be discussing, and many of the examples of previous meeting agendas and notices can be found on ADWR's website, as well as we put together a great notice and agenda for you today to use as sort of a template or guideline. So if it's not on the agenda, you cannot discuss. All discussions must be reasonably related to an adequately described agenda item, and you will need to add new items to the agenda for a future meeting. So if we're discussing topic A, somebody in the public or even on the council says, oh, wait, that jogged my memory about item B, we'll need to table that discussion until the next meeting when it is properly noticed. Making sure that changes in the agenda are going to be posted and distributed same as the original agenda, and that the 24-hour still applies. And same as before, if that changes to 48 hours, that will be 48-hour notice. So if you decide a week ahead that you want to discuss A and B, and 3 days before the meeting, you find out tacked on agenda item C, you can do that. You just need to put in a new notice and properly inform the public that that will be discussed. And this is a legal case that is going to provide some background on open meeting laws. That is Welch-Wecoachee City Board of Supervisors, a Arizona appellate decision from 2020. For those online, you can see actions taken by the board establish intentional violations of open meeting laws. In that instance, you will need to recess the meeting and resume more than an hour after time provided meant the public was not adequately noticed. Agendas that do not indicate the board was considering one of its own members for the position, or calls to appoint board members was the first action taken after executive session. So as mentioned with minutes, those are going to be required. They either need to be in writing or recorded via audio or video. And as mentioned before, make sure it's clear if we're going to be recording it. Contents of minutes need to include date, time, and place of the meeting, members present and members absent. General descriptions of the matters discussed were considered. Accurate descriptions of legal actions proposed, discussed, or taken on how members voted. Names of members who proposed each item or motion, and the name of each person making statements or presenting material, and a reference to the legal action addressed. That last one there would apply to both council members as well as members of the public. As mentioned, we cannot require a sign-in sheet for anybody that wants to come in. Anybody that wants to speak needs to provide their name for the record. Public access to minutes. Minutes for recording shall be made available for the public within 3 working days after the meeting. They make a tape available, which is a little outdated. In this case, obviously, you just include a link to whatever it is, the cloud, I don't know, where the meeting is housed virtually so that they can view it. And you can stamp as a draft if it's yet to be approved by the council itself. So the public right in attending these meetings of the council must be permitted to, all the public must be permitted to attend the meeting. They may attend without signing in, as mentioned a few times. They are not given a right to speak just because there is a meeting, unless the public body allows it. It's always advisable to hear what the public has to say. But if they do make a presentation, they must identify themselves. And in doing so, they cannot disrupt the proceedings. But if you need to remove somebody for being a disruption, make a record of it and make sure to give them, fair warning that they're being disruptive prior to removing them, and can record all or part of the meeting. That would be members of the public can come in here and record all of the public meeting, regardless whether or not we're additionally providing a recorded copy. And just a little bit more on disrupting the proceedings. If they care to, if you do open up the floor for discussion on a topic and they start getting off into a topic that's not before the board, you can let them know that they're straying off topic and that, this is something that the board cannot consider at this time, but may decide to table the issue. And as well, you can limit the time in which somebody speaks, especially because we want to make sure that these meetings don't go forever and that everybody gets an opportunity to speak. So providing somebody with 2, 3, 5 minutes to speak is absolutely acceptable. So in those calls to the public, be, they are optional. If you are going to provide people with the opportunity to speak, you gotta be fair. You can't just choose your best friends to speak. You gotta let everybody speak, even if you know that they're gonna disagree with you. Avoid getting into discussions not on the agenda, and the public body's response is limited. You may direct staff to study the matter. You may respond to criticism if somebody is up here criticizing you with their time. And you may also schedule the matter for a future discussion, as mentioned. Meeting etiquette. You're going to want to discourage the following among yourselves to make sure that you're in line with the meeting laws. Whispering to other community members, passing notes between council members, letting members of the public come up here and talk to you all each individually, maybe covering your mic while they're doing that. Avoid any of that behavior. And if it's about business of the public body, that could be a violation of open meeting law if it's being discussed prior to or after a meeting is taking place. If they want to come up here and say hi, that's fine, but you may want to just do that from a distance. And in any event, it looks like a violation, somebody can bring it up to the AG's office, and that just would create a headache for everyone involved. Executive sessions, there are special requirements for executive sessions, still requires an agenda and notice. Meetings, meeting and minutes of those executive sessions are confidential. So if there is an executive session, it needs to be on the agenda and notice that there's going to be an executive session taking place. But you may, when you go into executive session, leave the room to go to a private place to have that discussion. Meetings, minutes will still be required, but those will be confidential. And be sure to consult with your attorney before contemplating an executive session. We'll be sure to advise you on whether or not it is an appropriate item to discuss in an executive session. Those categories that do qualify for executive session are personal matters, confidential records, legal advice, litigation, contract, and settlement discussions involving attorney consultation, employee salary discussions, international, interstate, and tribal negotiations, and purchase, sale, or lease of real property. Some of those are highly unlikely to apply to you. That's everything that counts. So what if there is a problem during the meeting? And this will specifically cover you guys get yourselves in hot water. Here's what we do. So actions to take if there is a violation. Be sure to ratify the action, which would be described in ARS 38431.05B and discussed a little more here. Be sure to consider self-reporting. It's always better to just say, hey, I think I may have violated open meeting law. Here's what happened. Here's what discussed. And we'll figure out what to do about that. Cooperate with the county attorney, EG's office, or ombudsman's office, and move early to remedy the problem. Consider training and changes to policies to prevent violations in the future. Of course, we're giving you a little purview here, but if at any time you become fuzzy or you need a refresher on these points, we can handle that. So what is ratification? Again, Welch v. Cochise County Board of Supervisors provides clarification on the effect of ratification. Ratification ensures effectiveness of decisions, but does not preclude possible sanctions. Next slide. The ratification must take place within 30 days after discovery of the violation or after discovery should have been made. Clear indication in agenda and notice of the ratification, so that would be in a subsequent meeting. Detailed written description of the violation and associated deliberations, consultations, and decisions made available to the public, and a notice a written description available within 72 hours before the meeting. So if we do find that there's been a violation, what can the AG or county attorney do? They may investigate the issue. They may issue investigative demands, may conduct examinations under oath, may require written statements under oath. They may file enforcement actions in the Superior Court, and they may seek removal. The Arizona Ombudsman's Office as well has a purview over open meeting law, and they can investigate open meeting law and public records complaints. They can take anonymous complaints, and they can also offer training. Most of those trainings are publicly available. If you just go to the Arizona Ombudsman's Office, they're constantly doing trainings that are either in person or often online. Even if it's listed for a specific agency, so say maybe it's Arizona Department of Water Resources or Arizona Department of Health Services training, you can still log in and do that even though you're not a member of that body. Private parties. Open meeting law allows private rights of action, so that means that the public can take action if they believe there is a violation of open meeting law. Taxpayer suits are permissible whether or not the individual attended and would have been able to attend the meeting or would have attended the meeting. And the AG will defer to the court if the matter is filed in Superior Court. Penalties. The action is null and void. So if we take an action that is not properly noticed and not properly ratified, that any actions will be null and void. It is possible to have a $500, up to $500 fine for each violation against anyone who commits a violation, against anyone who knowingly aids, agrees to aid or attempts to aid another in committing violation. It's against the individual, not the public body itself. So it's very important. There is no fund that the council will have to take any of those legal fees, even if that was available, would not be available to you if there were a violation that would go specifically to you, and you would be responsible to pay those penalties. And you may have to pay attorney's fees and costs as well. Removal from office. If it is apparent that the intent was to deprive the public of information or the opportunity to be heard on purpose, the court may remove the public officer from office and, of course, assess those attorneys. Any questions? Yes.
Will you send this PowerPoint to us online?
I believe we will, and we will also be posting it as part of an agenda item that was presented before the council today.
Thank you.
I have a question. So you were talking about legal counsel. I remember specifically whenever the goal was first discussed, there was someone in the audience who had said they would bring legal action against the management goal. So would we be held accountable for that, or what would be the process on that?
Good question. Thank you. That management goal was put forward by ADWR. While you have recommendations for the director on what those goals should include, policies that will be implemented as such, that will be a decision and action of the director and the Department of Water Resources. So should there come litigation as a result of that, it will be handled by ADWR. And that suit would probably be filed against ADWR.
Good, thank you.
Of course. That was a lot. So if you have more questions, please let me know.
Do you have a business card?
I do. I can provide that to you.
Thank you.
Yes. All right. Thank you.
So just another quick question here, just thinking about Jackie's question regarding three of us being on this committee. So if we are to have that discussion, we need to have that right now to just talk about that, or is that?
We would have to post it as, I'd have to get hold of Nick and tell him that, because we have our monthly meeting. And so he'll have to post that there will be a quorum at the meeting, but at the meeting, we would be discussing stuff for this council, would be discussing stuff for the water allowance.
The other thing I can do is I could probably just delegate what I'm doing on that council to somebody else on the staff, so that way we don't have a quorum.
That is also.
That's,
Because I'm the county engineer, Lisa's the city engineer, so we work on a lot of projects, including some with water.
yeah, and I was just wondering, or removes myself from that group or something like that.
You're just trying to get out.
Right. And of course, your expertise in the field is highly valued, so it's not a surprise that you may join together in some other role beyond your roles as the council. If you have the option of sending staff on your behalf, that's great to avoid any image of impropriety. But you can just notice that meeting of the forum, that would be fine. The discussing of setting that meeting and whether or not, 3 of you are going to be there, and then getting with ADWR staff to make sure that that is properly noticed. That is not business of the council, so you don't have to discuss in front of us right here, when you plan to hold the rest of your meetings this year. Just make sure that when you do have those discussions, nothing, no council, but GUAC business comes into that discussion. Thank you.
And if there's no more questions, I'll chair them. Please introduce the next agenda item.
The next agenda item number 6 is AMA establishment overview. That would be done by Casey.
Thank you, Jackie. Thank you, members of the council, members of the public online and in person. I'm staying here to speak about AMA establishment. Said, if you've been to one of our public meetings before, some of this might be familiar to you, but I hope that you will really get some useful information out of it.
Could you get a little closer to the mic?
Sure.
Thank you.
So the Groundwater Management Act of 1980 created the areas of water resources. It also created the ability to establish.
They still haven't, they're still having in the office, in the audience can't hear you.
All right, so the Groundwater Management Act of 1980 established the area management plan of water resources. It also established the ability to create IMAs or irrigation non-expansion areas and AMAs, active management areas. This act also authorizes the establishment of new AMAs by election, which is what happened here in Douglas. It establishes the GAC, Groundwater Resources Advisory Council, for each AMA. Just kind of a helpful definition for irrigation in terms of IMAs and AMAs. Irrigation, as we're referencing IMAs and AMAs, means to apply water to 2 or more acres of land to produce plants or parts of plants for sale or human consumption, or for use as feed for livestock, range livestock.
Just one more note, Casey. We're still getting some messages online. Just please speak up.
Oh, sure. So existing active management areas and irrigation non-expansion areas. There are 6 AMAs in Phoenix, Prescott, Pinal, Tucson, Santa Cruz, and now the Douglas AMA. And then we have 3 IMAs as well. The Joseph City IMA, Arcopela IMA, and the Walleye Valley IMA, which is also established in December of 2022. Next slide, please. So here's just kind of an overview of the regulatory structure in terms of water rights in Arizona. So statewide, whether or not you're an INA or an AMA, everybody is required to register their wells. And they're required to prove adequate water supply. And community water systems documentation is also required. So just your general municipal water systems have to give documentation for the water that we use. With an INA, that's expanded to mean irrigation acres are prohibited, so no new irrigation acres can be created. And it also establishes the need for monitoring and reporting of groundwater in those instances. And then to the AMA, we add on top of that, so all those requirements from statewide and the INA are wrapped into the AMA. We're also adding insured water supply,
grandfather rights, and groundwater withdrawal fees, which now define those, and management goals, management plans, and conservation programs that further the management plan to conserve groundwater in our city. Next slide, please. So some examples of major characteristics and programs exists with AMA. Prohibition on expansion of irrigation acres, metering and reporting requirements. Like I mentioned, there are no withdrawal fees unauthorized in subsequent AMAs. There is a management goal, a management plan, wells requirements, impact analysis for new non-exempt wells, and then groundwater rights and withdrawal. So
On the well requirements, so this is for all the non-exempt wells, for the ones that do or they're irrigating. And what's the difference between a new well and a replacement well?
A replacement well would involve a currently existing well that for some reason needs to be moved because of either change in the layout of the land. Maybe the well has become defunct and needs to be updated, something like that. Or perhaps it needs to be dug a little deeper and there's problems with the current site. Any of those would be considered a replacement well that would need to be permitted by the Department of Water Resources. And the forms and procedures for replacing, modifying, or abandoning a well can be found on our website.
Is that just domestic irrigation wells, or does it include domestic wells also?
There are different forms and requirements for exempt and non-exempt wells, but every well in the state of Arizona needs to be permitted by the Department of Water Resources.
So it's not this, we're not preventing drilling new irrigation wells if it's replacing an existing well.
Correct. Yeah. In that case, it wouldn't be considered a new well. Just a little legal clarification there.
Huge legal.
So what happens in the case you say every well is to be registered, and I know across the land there's instances where there's wells that aren't, they're old, they're just on the land. So if a well isn't registered, does anything happen? A person can technically just withdraw from it with no ramifications?
The specifics of each case, depend on what would happen. But especially if it would be qualified as a non-exempt well, compliance action can be taken against that individual.
Clarification, because under the INA, I mean, the irrigation right is to the property, not to a well, correct?
Correct.
Good questions. Thank you. Thanks, Anthony. Appreciate it. So as far as groundwater rights and control authorities, those applications are available on our website. Person can go to the department. Failure to apply for a grandfather right by the deadline, which is now September 3rd, 2024, will result in the waiver and removal of any right to use that. So a little bit about the Douglas Active Management Area. It is the first subsequent AMA that has been established since the original AMAs were established. And it's also the first to be established by local election, and that was done on December 1st, 2022. It is located entirely within Cochise County, and it encompasses the previous Douglas INA with a new boundary around it, encompassing a bit more of the basin. And kind of hard to see on the projector there, but the previous INA is the dotted line there, and the AMA is the new boundary that surrounds that. So who is allowed to use groundwater in an AMA? As far as the exempt wells goes, generally, a person may withdraw groundwater for a non-irrigation use for a well having a pump with a maximum pump capacity of 35 gallons per minute or less without a right of way. However, there are some limitations on the use of exempt wells within the AMA. Some of those limitations include only one exempt well may be used to serve the same use at the same location. and withdrawals from an exempt well for a non-irrigation purpose other than domestic use, stop watering, are limited to 10 acre feet per year. So to put that in context, it's over 3 million acre feet per year.
And at the same location, is that if somebody has 80 acres and they have, I mean, so it's under their property ownership of 80 acres, can they have two non-exempt well or two exempt wells because they have two homes on the property?
I believe, if I remember correctly, the Department of Water Resources regulations provide a description of what would be considered in the same location. I believe that's specifically listed, the distance that would be required.
As far as non-exempt wells go, within an AMA, a person may withdraw groundwater from the well with a maximum capacity greater than 35 gallons per minute, only if the person holds a right or permit to withdraw that groundwater. So any person irrigating 2 or more acres or using 10 or more acre feet for a non-irrigation purpose must file an application for a grandfather right or obtain a withdrawal. And then again, just a bit of a note about the deadline of September 3rd, 2024 for that grandfather right application.
One other question. So we have, you know, as a county engineer, we do construction projects and the contractor has to have construction water, which they use a lot of water. And before they've gone to some of the farmers and have obtained construction water. Well, now that, so does that well have to have a withdrawal authority for construction water? And can you get those in the future? Not, you know, because you don't know, you know, 10 years, you know, might have a construction project next to someplace else that makes it more feasible for the contractor to get their construction water adjacent to the road instead of driving, you know, 20 or 30 miles to get it from the city of Douglas or Elfrida.
That is another excellent question.
That is something I would have to look into specifically. But I will note that most of the AMA requirements typically apply to residential and irrigation and that sort of thing. Anything that would be considered commercial typically is handled differently.
Anthony, this is Natalie Mast. Can you hear me?
Yes, we can, Natalie.
Okay, thanks. And to the members of the council, I apologize that I wasn't able to be there in person today. This is Natalie Mast. For those of you who might not know me, I'm the Active Management Areas Director at ADWR. For the question for construction water specifically, so grandfathered rights are specific to a non-irrigation use or to an irrigation use. So something like a farmer allowing a construction use to use their well, that might not be appropriate because the right associated with that farm is going to be an irrigation type of right, and that water can only be used for irrigation purposes. So that's not to say they wouldn't be able to use the well, but they might need to lease a type 2, for example, so that they have a non-irrigation withdrawal authority that they're able to report that water use under. Does that answer your question?
Yes, thank you.
Thanks.
Thanks, Natalie. Did you have a question, Al?
I couldn't quite understand what she was saying. Did she, can I sell water to you or not?
You have to get an authority to do that.
And I can go to ADWDR and you'll send me a little note that says you can sell them 100,000 gallons.
It's of course not that simple, but in practice, yes.
You have to have a commercial. I mean, I knew the answer, but there's been people that have asked that.
The gas company asks me all the time.
Yeah, but you would have to have another authority to withdraw water from an irrigation well for use other besides irrigation.
Correct. Yeah, that would just be a different right.
So you'd have to do that application before the September 3rd, or that's a completely different thing?
I believe that's completely different.
Yeah, Sorry, this is Natalie again. Yes, so there are non-irrigation grandfathered rights. And so for those grandfathered rights, that deadline is September. But there are also other types of industrial type or non-irrigation type withdrawal authorities that can be issued, particularly on a temporary basis within AMAs. Those are called general industrial use permits or other types of withdrawal authorities.
So the last question I have about that is, if, say, El Paso Natural Gas wants water from me, can they apply for it so I don't have to do the paperwork, or do I have to apply for it?
So something we've seen in the past is that the industrial water user, the natural gas company in your example here, might apply for the general industrial use permit or the withdrawal authority there. And then you and that company might have an agreement that they could utilize your well in order to withdraw that water pursuant to that authority. Did that answer your question?
Well, it begged the next question. Do I need to get documentation from the person that is wanting to use the water that they have that authority? Thank you.
Yeah, maybe that's something you and I can talk about, Ron. I'm not sure exactly how that's been handled in the past. That's something I might need to look into.
Okay, thank you.
Thanks.
And just for the record, I was shaking my head there because I believe that would be advisable. But we could look into that specific issue because that is something that we haven't addressed in the past.
All right, great. Does anybody else have any other questions? Now I'll go ahead and pass it back over to Trey. Thank you.
Item number 7, AMA management plans, and Madison will present that.
Thank you, Chair and members of the council. Good to see you all here today. I'd like to reintroduce myself. My name is Madison Moreno. I'm the AMA Establishment Coordinator, and I'll be going over the basics of the management plan and a timeline. The director shall develop a management plan for each initial active management area for each 5 management periods. We shall adopt a plan only after public hearings. The plans shall include a continuing management conservation program designed to achieve reductions in withdrawals of water. So we have created a management goal, which then pushes towards the management plan, which then creates the conservation programs that will be implemented by people of Douglas Basin. And they all kind of interlude together in the circle that I have on the presentation slide. You've seen a few of these before, but our management plan is here. We have had many meetings down here to get public input about what needs to be included in these management plans and what makes Douglas unique, and creating those plans to provide the most effort we can to help out people with the Douglas Basin. We are required by statute to put out the management plan 2 years after the designation subsequent AMA. So that deadline is at the end of this year. Hopefully we are on track with that, and it's looking like it so far, and getting that published in December. So we have been in the development stages currently, drafting and hopefully getting some input on those through comments. We have had many meetings, as previously mentioned, to discuss conservation programs, what works, what won't work for people with Douglas Basin. With the initial management plan, principles are reducing groundwater withdrawals. So these conservation programs are to help reduce groundwater withdrawals. We are also working on education of these conservation requirements and trying to be as open and available as possible to the public with any comments that they may have regarding this. Here is our tentative management plans timeline, the Douglas AMA. We have gone through the public meeting portions and follow-ups and frameworks and education meetings about different topics of the management plan. So the main 3 conservation programs are agricultural, municipal, and industrial. We've also had meetings about recharge and the voluntary measures may have in there. We are hopefully going to publish the regulatory language draft at the end of this month, beginning of June. We're working on that timeline now. And we will present that to the public via email and on the website. And we are taking comments on that draft. And we'll put a deadline to those comments on there too. So be ready to receive an email from me with those comments. Be ready for that. Very excited to propose these new programs and ideas that we have for Douglas and follow with being able to publish. Next slide, please. Yes.
So once that draft comes out, if we individually have comments, can we submit written comments as a
Yes.
farmer, not as, okay.
In August, we will have our next meeting here to discuss the full draft of the management plan for first management of Douglas. And we will ask for your comments, and we will be the first ones to see the initial draft. Once we conduct that and have our comment period open, we will have our formal comment period begin and ending in November. And then the adoption will take place in December. With the adoption taking place in December, the management plan will not be enacted until January 1st, 2027 is when the conservation requirements will be enacted and effective.
And how long is that management plan good for then?
The management plan is good for 10 years. Every 10 years, we write a new management plan.
10 years as of January 2027.
I'm not quite sure on that date, but I'm going to get back to you on that.
I can take that. Sorry about that. This is Natalie Mast again. The management plans each stay in effect until the next management plan takes its place. So the idea is that you would have the next management plan so that it becomes effective 10 years after the first management plan is effective. If for some reason, as has occasionally happened in the other AMAs, that timeline isn't quite met, the first management plan doesn't go away. It remains in effect until the next one becomes effective.
Good.
Great, thanks. As I mentioned, there's just a brief timeline. Because the designation of the Douglas AMA was December 1st, 2022, our tentative promulgation of the initial management plan will be December 1st, 2024, 2 years after designation. And the effective date is then we're pushing it a little bit, 2 years to make it a full calendar year, January 1st, 2027. Like I said, we will be publishing the draft regulatory language and have open time for public comment at the end of this month or beginning of June. And we will post the draft management plan and present that to you all in August. Are there any questions regarding the Thank you. If you have any other questions, please feel free to reach out to me.
Thank you. Agenda item number 8, the AMA Director Report. Natalie?
All right. Chairwoman and members of the council, excuse me, sorry, I'm getting my notes in front of me. I apologize. I apologize that I wasn't able to be there in person today. I would have really liked to be there in person for this first meeting of the Douglas GUAC. So please accept my apologies that I'm not able to be there today. I had just a few updates that I wanted to make sure we were providing to the council on kind of general ADWR and AMA activities. The first one that I wanted to note is you will have noticed that Ryan Melson is there in my place today. So I wanted to give a big shout out and a thank you and a congratulations to Ryan. Ryan is in his first week as our Deputy AMA Director, and I'm just really pleased to have him to help me out with a lot of things. So you all will be seeing a little bit more of Ryan. Ryan previously was our conservation programs supervisor, so he's not super new to the agency. He's been with the agency for, I guess we're only probably at like 8 months or so, but Ryan can maybe correct me on that. But we are really grateful that he has agreed to take on this role. So I am still going to be involved in the Douglas process, and today just did not work out for me to be able to make it down there, and I do apologize for that. I was really hoping to be able to be there for today's meeting. The next item on my list that I wanted to mention was a little bit of an update on the Governor's Water Policy Council. So folks may remember that the governor convened a water policy council and tasked them with providing recommendations specifically related to assured water supply and related to rural groundwater. The council did issue those recommendations in December. And since then, ADWR has been working pretty intensively to develop some of the concepts related to those recommendations through additional stakeholder meetings, through the development of draft rule language for an alternative pathway for providers to obtain a designation of assured water supply, and also through ongoing interactions with the legislature and with the governor's office. Those discussions are ongoing. I don't necessarily have a specific update on that today, but they are still constituting a significant time demand for many department staff, and we are really hopeful about where those discussions are going and the potential benefits that those discussions can provide to the state in the future. We'll certainly be sure to continue updating the council on the progress related to those discussions, and if there's any items of relevance that the council may want to discuss. The last item I wanted to mention is related to modeling efforts. So as a part of the establishment of the Douglas AMA, ADWR has been actively expanding its data collection efforts in the area. So staff are, we have field services staff who go out and take well measurements, aquifer test measurements. They can talk about that much more intelligently than I can. But we are very, very regularly looking for additional wells to take measurements from, particularly if there might be an opportunity to have a long-term series of measurements taken from a single well or a single location. So I wanted to take this opportunity with the council and with the public to just kind of make a little bit of a pitch or a shout out for those activities. We would love to hear from folks if you'd be open to collaborating with us on those measurements. And I would be happy to direct any inquiries about those measurements to the appropriate team in our hydrology group. The last thing I just wanted to say before I turn it back to the council and Chairwoman Watkins is that I'm really grateful for you all. I wanted to express my gratitude to each of you for the engagement that you've already shown with this Douglas AMA process. I know it has felt slow at times and has felt intense at other times, but I really appreciate your willingness to serve on the council. We at ADWR are really looking forward to continuing to work with all of you as we move forward with the management plan and as we move forward with other items related to the establishment and operations of the AMA. So thank you. And that's all I have for now.
Thank you, Natalie. Call to the council.
To clarify this, if there's any remaining questions from council that they'd like to ask.
Anybody else have any questions?
Madam Chair. I do.
Yes.
All right, I might direct a question. I think it would go to Mr. Allen. In your planning process, does DWR interface at all with the Natural Resources Conservation Service to look at soils information and productive capacities of various soils?
To my knowledge, no, we do not.
It might be interesting to have the director contact the state conservationist of Natural Resources Conservation Service to establish a conduit so the planners can talk to one another between the Soils Department with the NRCS and the DWR. Because associated with each soil series, of which the entire state, private and state lands have been mapped, they associate an agricultural capability classification. It'd be interesting to get those polygons overlaid over your AMAs or the Douglas AMA or the whole state as a planning vehicle to give you more scientific or technical data to petition the director, the governor, and the state legislature to possibly establish some long-term goals on how much prime farmland we want to put houses on and how much we want to remain in agriculture, because a lot of the farmland in this state is second only to the Nile Valley in the world for productive capacity, and it's would provide a vehicle to you for you to establish that technical data and hold the state legislature's feet to the fire and get guidance. Say, we're going to subdivide the whole state, or we want to protect these acres, and it would certainly help producers on the ground to know they have some sort of security in the future.
Absolutely. I mean, yeah, I would love to have as much scientific data as possible that it's the most accurate information and it's helpful for the state and for the people. So I really appreciate that suggestion. What was the name of the organization again?
It's a USDA Natural Resources Conservation Service.
It's a federal government.
Yeah, it's federal, USDA. And the director would probably want to contact Keisha Tatum, who is the state conservationist. That way they could coordinate. Yeah, it's okay if you talk to them and them talk to you, and we exchange GIS files electronically.
Yeah, no, absolutely.
If you have any questions, I know you have my number and email address.
Yeah, absolutely. Sure.
Thank you very much. Thank you, Madam Chairman.
Call to the public.
I had something. Slow down. You're done. So I was kind of thinking about what Natalie was discussing with the Governor's Water Policy Council, and I guess I was just trying to understand our positions here as council members, and thinking about all the work that's been going on with the Governor's Water Policy Council and all the things that they're trying to do to develop a third option or something that's different from an INA or AMA, and just wondering where that leaves us who are in AMAs with reference to what the Policy Council is doing, and if we ever have any type of interaction or, ability to discuss the similar things that they're discussing for the communities that are outside of the AMA, for example, Wilcox Basin.
Sure, I can take that. It's a great question, and kind of according to open meeting law, that would be something if we wanted to discuss it as a part of a meeting of the GUAC, we would have to put that on the agenda and have that conversation. We can absolutely do that and talk in some more detail about what those recommendations from the council were and kind of the conversations that have occurred since those recommendations in December. But I guess I would defer to the chair on whether those, the council and the chair on whether you would like those on a future agenda.
We can add that to the next meeting's agenda.
Thank you.
Appreciate it.
Any other questions? Call to the public. Is there any of the public online or in person that would like to make a statement?
To clarify for those online, please indicate that you would like to speak before you're unmuted, just so we don't have anyone talking over each other. And once you indicate that you'd like to speak, thank you. Do you have any questions from those present?
My name is Amanda. You can come up to get microphones so that we make sure we get the recording. Sorry.
Sure. Thank you. Hi, my name is Diana Lamar, and this happens in this room all the time. You really have to be on top of your mic, or we can't hear you, especially for those of you whose backs are to the public. It's very difficult, and I know some people are comfortable speaking publicly, but just because there's a mic in front of you doesn't mean you don't have to speak up. You really do, or we won't hear you. I just wanted to encourage that. Use your mic.
Thank you.
We do have an attendee online who's asking for questions to be read on behalf. Christian Sawyer has 3 questions in succession. Their first question was, does ADWR plan to have any further public workshops on the DANA management plan ahead of the formal public hearing?
I don't know, Madison, if you wanted to take that, or I can take that.
I can take that. We do not plan on having any more management plan workshops, meetings currently. We will be open to any comments that we receive through the comment period of the regulatory language that will be posted at the end of this month.
Thank you. Christian.
Oh, sorry, Nick. I just wanted to add a little bit to what Madison said there. We don't want to want folks to have the impression that just because we're not having public meetings means that we're not hoping for additional engagement from folks on the management plan. Part of publishing the regulatory language is to invite additional comments on specifically that language, which we really see as kind of the meat, the critical portion of the management plan. So we do hope that folks will review that language, will submit comments. We will be, there will be a public meeting kind of in the sense that we will be meeting with the GUAC to have additional discussion of the management plan ahead of announcing the hearing. But we don't intend to have separate management plan meetings at this time.
Thank you, Adam. I'll now read Christian Sawyer's second question in its entirety. In the many discussions that ADWR has had about appropriate management plans and conservation programs for the Douglas AMA, has the agency anticipated requests from the GUAC and public, which you have already decided?
I'll take that question, and thanks, Christian. I think the kind of simple answer to this is no. We are open to seeing the types of comments that we receive. We think we've had good conversations with folks already about the management plan and the conservation programs and the things that we're developing that are really unique to the Douglas AMA. And we're excited that we've been able to customize so much for the Douglas AMA. There's not anything specific that we really anticipate, and there's definitely not anything that we've already decided against considering.
Thank you, Natalie. I'll now read Christian Sawyer's third and final question. Has the agency decided that the statutory deadline to, excuse me, this is some quotes, I apologize for an incorrect pronunciation, promulgate the management plan, which means that it must be adopted by the date? If not, is there any reason for choosing to use that date for the adoption rather than allowing that date for promulgation, and then subsequently holding the public hearing and issuing the order for adoption, so as to give more time to the GUAC, the public, and ADWR more time to discuss the first management plan, which, as we all might imagine, could benefit from a few extra months of careful and collaborative discussion. Thank you, Christian.
So promulgation really refers to the legal process by which those management plans are adopted, and perhaps Anthony will want to chime in here. Maybe this is more of a legal question than anything, and I'm not there for Anthony to kick me if I step out of line here. So but promulgation typically refers to that legal process by which the management plans are adopted. We hope to complete that legal process. That legal process has defined timelines, and kind of the sum total of that timeline is 60 to 90 days for that whole process to complete. We see it as in the interest of the AMA for that full process to be completed by the end of the year, so that the management plan is able to go into effect sooner, rather than pushing it out another few months and having to wait a full another year for that management plan to go into effect. And I would let Anthony add anything to that if he would like to.
Natalie, that was great. Thank you. I will just add that the timeline she is discussing is statutorily defined.
Thank you, Natalie. Are there any more questions for those in person or online?
Hi, Diana Morgan. Without minutes or a recording being available from the meetings that have taken place, the AMA meetings, it seems a little hard for people in the public, and maybe even for our council members. I'm not sure how you feel, but without having a record of the discussion or minutes of the prior discussions, it's going to be a little hard to review drafts. I don't personally remember everything that was said at those meetings, since there's not a record. I'm not sure what to say about that. I know that I did ask about minutes being taken at one of the prior meetings and was told that they were not being taken. I'm not sure why they aren't. I am happy to hear that Natalie said that they were looking forward to specializing the plan for Douglas, but I have had the sense at times that ADWR would like to have the Douglas AMA conform to other AMAs. And so I just hope that there's a way to accurately reference prior concerns and comments and suggestions so that we know that they are being integrated. Thank you.
Thank you. I'll hand it to you.
I do know that if there was written comments, those written comments you can get online from prior meetings or prior drafts.
And then as far as previous public meetings that we've had, recordings and the actual like slide decks for those meetings have been posted on the ADWR public meetings website. But if you do find an instance where that's not there, and you know that a meeting took place, like please reach out to us and we'll be sure to upload it immediately.
I'm not sure, Natalie would know, I'm not sure if the workshops were recorded because we had different tables going.
The workshops themselves would be collaborative discussions about potential conservation programs for Douglas were not recorded. The presentations themselves were.
Thank you, Madison.
And just an additional note on that, any publicly available information such as those minutes and agendas and presentations, anything that is not already published online can be requested through a public records request.
Thank you, Anthony.
And so Madison, the workshops that we held where there was discussion, so that is not publicly available, but that's what's informing the next thing that's going to be put out here in, what is it, an August informal draft. Is that correct?
Yes.
Okay.
Unless there is no objection, I will adjourn the meeting.
There is one model comment from the public, from Christian Sawyer. He already gave his comment in its entirety. Historically, the ADWR has treated the statutory language of promulgate to mean to circulate proposed plan ahead of the public hearing, as was done in 2022 with the management plans for the 5 initial AMAs, as distinct from the statutory language of adoption. I'll hand it back over to you.
Madam Chair, can I ask a question of
Yes.
staff? Is there some pending litigation? And I'm just asking, is there something maybe we need to have an executive session just to get kind of
You need to get
updated or aware of?
I would like to avoid commenting on any ongoing litigation, though there have been proceedings brought forth challenging the establishment of this AMA. That, as mentioned with the previous question about the management goal and any litigation that may arise as a result of that, that is something that is being handled by the department. And any further discussion that the council may want to have about that litigation, to the extent that we can share, would be discussed in an executive session.
May I ask, is it anything that would disrupt what we're being tasked with doing here?
As of it stands, no.
You can't be heard by the audience. Get to the mic. What was your question?
To repeat the questions were regarding any potential litigation going on around the establishment of the AMA, the Douglas AMA, and how that may affect the council and whether or not that should be discussed among the council. And then additionally, a follow-up question inquired as to how that litigation may or may not impact the timeline of the duties before the council, if I summarize that correctly. Thank you.
Thank you. Any more questions online?
No.
Unless there's no objection, I will adjourn the meeting. Hearing no objection, the meeting is adjourned at 2:39. Meeting adjourned. Please, when I first started, is the recording off now?